Hello friends, in the series on the income tax cases, today we will discuss the case of Gujarat Smelting and Refining Company Limited versus Income Tax Officer. This case has been reported in 106 ITR Tribunal, short notes 93, and the matter has been decided by Ahmedabad ITAT C bench and the date of the judgment is 29th August 2023. Friends, generally there is a misconception that if the assessee has filed a return of income with some losses and during the assessment proceedings those losses are reduced or the losses are converted into profits, then the amount of losses reduced to zero does not attract penalty under various sections of the Income Tax Act. In this case, this thing has been made clear by the Honorable ITAT that there is explanation 4 to section 271 subsection 1 clause C, which specifically mentions that if the losses are reduced or if the losses are converted into profits, then the department can initiate and impose penalty under section 271 subsection 1 clause C on the basis of concealment or furnishing of inaccurate particulars as the case may be. In this case, the assessee has filed a return of income with a loss of 2 crore 17 lakh. During the assessment proceedings, there was allegation on the assessee that the assessee has made bogus purchases of near about 8 crore rupees. During the assessment proceedings, the addition was made into the income of the assessee on the basis of some percentage basis of the bogus purchases into the income of the assessee. No doubt it was on the basis of estimation, but because of this addition, the loss figure of 2.17 crore converted into a profit of 6 lakh rupees. If we calculate the difference between the loss figure and the profit element which came after the assessment, that figure is coming 2.25 crore in this particular case. It was the opinion of the learned assessing officer then that in this case, this difference of loss and profit is the amount of concealed income and the penalty under section 271 subsection 1 clause C according to explanation 4 should be imposed on the assessee. The assessee pleaded that I do not have to pay the taxes, only my losses have been reduced, and if some profit element is also coming, then the penalty should also be imposed up to only that amount. And the second plea of the assessee was that this addition is purely based on estimation because no exact amount has been added, ad hoc addition has been made, some estimation has been made. So in these type of cases, the assessment order or the penalty order does not qualify for as a fit order to levy penalty under section 271 subsection 1 clause C. But the assessing officer was not convinced and the AO go ahead with imposing the penalty. When the matter came before the CIT appeal, the CIT appeal said that it is not a matter of simple case of estimation of income and the assessee has not challenged the allegation of bogus purchases, so the penalty is very much justified in this case. The assessee moved to the ITAT and the ITAT upheld the order of the learned assessing officer and the CIT appeal that in this particular case, because the assessing officer has made a proper inquiry, the addition has been made on the basis of estimation of the bogus purchases. It is not a simple case of estimation. The assessee has done wrong and concealed particulars of income. So this order qualifies for levy of penalty according to explanation 4 to section 271 subsection 1 clause C, and the plea of the assessee that I do not have to pay the taxes, that does not work because if the assessee will be allowed this type of explanation, then the assessee will file his or her loss returns, then they will carry forward those losses, and it will have the impact of reducing the taxes in the coming years. So this practice should not be allowed. This is justified also, and the decision of the Honorable Ahmedabad ITAT bench is very much justified.